Appeals Division 1 is now in session.
Please be seated. Morning, Council. Court now calls case number CV1367, in re the matter of Richard A. Kent and Christine Carter Kent. This is the time set for oral argument. Council, I will advise you these proceedings are being audio and video recorded, and at the conclusion of this argument today, the proceedings will be available on the court's website within a few days, so I want you to understand that. When you step to the podium, please identify yourself and your client. As you are both well aware, you each have 20 minutes. If the appellant wishes to reserve some rebuttal time, please let us know when you get up to the podium. And the clock at the podium will help you keep track of the time. Counsel?
Good morning, Your Honors, and may it please the Court. My name is Scott Boehm. I am appearing today as appellate counsel for appellant wife, Christine Carter Kent. Today's dispute concerns the allocation of the community's interest in husband's law firm, Kent and Whittakin, Phoenix firm here.
Counsel, before you get into your discussion, would you explain to me what was intended in the initial decree? The initial decree I'm referring to is the one that was filed on October 6th of 2009. When the determination of your client's entitlement in the law firm, $460,000, was called an equitable offset. What did that mean by decreeing that she was entitled to an equitable offset?
I think they were just trying to, to make sure she got her fair share.
Right. Now, I understand the concept that you would take the offset and offset against some other property, but the decree doesn't seem to have specifically done that, did it?
No, and I think, I agree with you, Judge, and I think that's why the parties quickly realized that that wasn't going to work.
Was it just a fancy word for equalization payment?
Yes,
Okay.
that's what I think. But since there wasn't an actual judgment, that's why wife's trial counsel at the time filed the motion to amend.
I mean, not only there just was no direction as to how she was to realize the $460,000 in the original decree.
Yeah, I've never heard of that before, to be honest with you. But again, I think that's why counsel quickly filed the motion to amend to get that 460 reduced to a judgment.
And one other question again before you get going. I'm somewhat puzzled as to where I guess it's paragraph 8 of this same decree, where the court reserved jurisdiction to essentially revalue the law firm in light of the separate lawsuit. How did that end up in the decree? Because the previous rulings from Judge McVeigh in August of 2009 seemed to give your client an interest in the lawsuit, as opposed to saying that I'm going to revalue the law firm. Somehow it just ended up in this decree, and I don't know how that happened.
Well, I think the way it came down, and the reason for this language, and I had to read it several times, this language, before the kind of light went on for me too, is at the time of the trial back in November, and I may be going back too far, but
Yeah, in fact, my question is actually more mundane than that. I kind of understand the concept, but how did it get in here?
well, the reason it got in there,
Because it seems contradictory to the judge's rulings in August that gave her not an interest in extra interest in the law firm, but an interest in the lawsuit, 25% of the lawsuit proceeds. That seems to be inconsistent with saying, well, we're going to give you more value in the law firm.
well, the proceeds that she was awarded it wasn't actually the proceeds. That was just a formula for determining her increased value. At the time of the trial, she got...
That's not the way it read.
Well, it kind of sort of does, I think.
I mean, this does in the decree, but I'm talking about the minute entries in August where
Yeah,
the
the
judge
August
says,
29-minute entry. keep in mind, when the evidentiary hearing was held on August 27, the purpose of that was to figure out some method of figuring out what the increased interest is. Because the community's interest in the increased value of the law firm based on the settlement. And at the time, after the first trial got over in November and December of 2008, everyone eventually got on the same page. Judge McVeigh was initially thought that had been considered. But once the factual mistake was clarified, then he set the hearing for August 27 to determine the method of division, because they were going to pick, husband's counsel had an idea of how to value the firm, and basically the choice was going to be, our position was that you take 25% of the net proceeds, probably, frankly, because it was easier to do the math, or the option would have been to go back from square one and reevaluate the entire law firm, taking into account the additional 1.5 almost. So that's where, and the August 27 hearing just chose between those two or some hybrid of them, and he selected ours. When that made its way into the decree, and the part you're referring to in paragraph 8, he said the court hereby reserves jurisdiction to determine the extent and apportionment of the community's interest in husband's shareholder interest. And so they were going to have to go back at the end of the August hearing. It was the calculations hadn't been done yet.
Right, it's just not to belabor the point, but in the minute entries in August, Judge McVeigh had refused husband's contention that wife could have no interest in a partnership asset.
Correct.
He said specifically, she's not entitled to the asset itself. She's entitled to her fair share of the
net
community
proceeds.
interest in the law firm as a whole, including all of its assets.
Right, and I think the reason for this language in paragraph 8 is because the math had not been done yet at that time.
But
depending on how it came out, I'm sorry, Judge, go ahead.
Isn't that a problem, though? Under 25327, I don't see any way for the court to just reserve jurisdiction and figure it out later. I think the court could have asked the experts to do what they declined to do, which is figure out some present value based on certain assumptions at the time of trial. The court could have come up with a formula, much like one would do when the house is ordered to be sold, right? Could have come up with a formula and said, okay, 460 now plus X later, based on a triggering event, and entered that in the decree. But I don't see any legal basis to retain jurisdiction and just reopen the proceedings later.
I think he did what you're suggesting he could do, is he gave her...
That he was retaining jurisdiction.
Yes, because he still had to, because the math hadn't been done at that time.
But
So
I
he
guess
couldn't-
that's where I have the problem. Legally, doesn't the math have to be done at the time the decree is entered? I mean, there are all sorts of occasions where there are orders entered that contemplate future events and order future payments based on formula, quadros, house sales, all that sort of stuff. But the courts don't retain jurisdiction to just take a fresh look at it later. They determine the formula, and then the parties live by it. So do we have a legal error here based on the retention of jurisdiction?
Well, I think that, that's a whole another issue, whether even if there was a legal error, if there's anything that can be done about that now, given the finality of the decree. But let me ask you a
And
question.
that's my concern. Yeah, go ahead.
I really think that the trial court did just what you're suggesting it had jurisdiction to do. The September 8 minute entry, which reflects the ruling after the evidentiary hearing, set the formula. 25% of the net proceeds. The math hadn't been done yet. And at that point, keep in mind this divorce had been going on for a while. Parties were anxious to get a decree entered. And it's kind of sort of in the nature of of a late discovered asset. And there was no question, and trial counsel for husband and wife agreed that she was entitled to some amount. and their expert agreed she was entitled to some amount. But they hadn't been able to do any of the math yet, because until the August 27 hearing, reflected in this minute entry that Judge Thompson you were referring to, that's when he set the formula. So then they could go back and do the math.
So
And that's,
it seems to me there's a couple of considerations that underlie what Judge Swan's talking about. If Mr. Kotzen testified that there is a way of evaluating that asset, that lawsuit, giving it its present value and adding that into the law firm's overall value, but he basically declined to do it. He said it was very expensive and complicated, and it would cost everybody too much to have me do it. So he said there was a way to provide the present value of that asset, even though the case hadn't settled yet, but he didn't do it. And the other thing that happened with Mr. Kotzen's testimony is that when he was suggesting the idea of, well, we'll just value the firm now, and then you can give her share of the proceeds later when this thing settles, is there was an objection from husband's counsel that said he's giving a legal opinion, and not necessarily a valid legal opinion.
although the trial judge ultimately accepted it.
He did.
And there again, I mean, this kind of gets back, and I'm sliding into another argument, but it flows over, Judge Swan, to your question of what can we do about it, is I think all of these type of arguments should have been made, could have been made, certainly, in 2010, when husband appealed from the decree and specifically the minute entry,
But
which
but
wasn't
here's the
necessary.
problem I see from your standpoint. I think everybody's on the same page now that there's no interest in this asset. There's an interest in the law firm. And if there's going to be any value passed on to wife from the asset, it has to be done by valuing the law firm. Yet she comes in and says, I'm done valuing the law firm. I want a judgment. It's $460,000, and we're not going to talk about valuing the law firm anymore. We'll talk about the asset, which is incorrect. So is she stopped from pursuing it now?
No, I don't. I think you're mistaken as to what they did.
Okay.
I mean, the judgment or the decree itself, which is ROA 126, was very clear in saying that the 920 netting 460 to her was only for the law firm. That value of the law firm as an asset, his interest in it, of course, without the Kimberly Kent settlement. He mentions that in the footnote, which was not changed in the amendment that gave the judgment. The footnote still exists, saying that we're going to decide the increased value. I mean, she gets this now, but the increased value is going to be decided as we talk about in paragraph 8, getting back to your thing. And then in paragraph 8, they specifically go through, we're going to be going and having this other hearing, the evidentiary hearing that's referred to. So that was just, it was a very specific extra component that wasn't, that at the time of trial was uncertain. Well, that's not correct. At the time of trial, it wasn't uncertain, but it had become so recently certain that the math hadn't been done yet.
But this happens all the time, and there's a procedure for dealing with uncertain payments that the judge didn't seem to use here. And so I wonder if the problem you face is that if the judge erred by retaining jurisdiction and should have just done the math at the time, then you could say, well, the judge made an error and that now it needs to be remanded to come to a final value of the law firm and just get it done.
Well,
And if your impediment to that is the fact that your client came in and said very clearly in connection with this $460,000 judgment, I just want my judgment, I'm done valuing the law firm. And if I'm mistaken in a understanding the record, please let me
Yes,
know.
you are mistaken. That
Okay,
is
tell me why.
absolutely not what occurred.
Okay.
She wanted to be able to collect her $460 for the value of the law firm without the Kent settlement. That's why the amendment and if you look at the motion to amend at the time, it was a motion to amend before. After the decree was entered, it doesn't mention anything about the settlement. She just wants to have some vehicle to collect her $460, which was, kind of partial payment, if you will.
But
I
the
thought-
husband said that wasn't final, and she said Yes, it is. This is all I want for the value of the firm, because I'm going to get what I have coming to me out of that lawsuit, because I have a 25% interest in the lawsuit, what she said. And husband said, I don't think so, but the judge said, okay, I'll go with that and give you your $460,000.
I think that's wrong. I think what the judge gave her was the judgment so she could collect the 460 and the interest in the law firm and everyone. And there may have been some inartful language, if that's the right word, at the argument or not in the motion, because she just wanted to collect her 460. There was no indication from wife's side ever. I mean, prior trial counsel has been screaming from the get-go in this case that she didn't get full value because she only got her 460, and that's undisputed. 460 has been paid. We're not complaining about that. But what Paulett and Pankow and the trial court and everybody understood was that she would be getting some additional money. Now, granted, I will give you, after the amendment to the judgment, they came in and said all this other stuff in Section 8 and the footnote, that doesn't apply anymore because she got a judgment. But none of Section 8 or the footnote where he retained jurisdiction was covered at all in the amendment. He just simply changed that wacky language that you mentioned before.
I agree with you that he did not change the retention of jurisdiction language when he entered the judgment. That's pretty clear to me. But the question is whether it matters, because if the retention of jurisdiction was legally invalid and wife asks for a judgment that encompasses the value of the law firm, expecting that she would later get something else that turns out to be invalid, does she have an avenue to relief?
I think this gets back to my primary argument on appeal, is all of that became final. And once they dismissed their appeal, and Ms. Sikander represented the husband at the time, she filed the notice of appeal on all these, well, I don't know what she was going to argue, but theoretically, everything you're arguing now. And then the appeal was dismissed, saying they wanted to move on. The dismissal of the appeal to challenge all these, to raise all these things, even lack of jurisdiction issues become final, and you can't raise them subsequently. I covered this really well.
Didn't he dismiss his appeal because he figured he only owed her $460,000 and he paid her?
No, he didn't say that. He just said he wanted to move on. I have the notice of, or the motion dismissal right here. His motion to dismiss appeal said, and I quote, although husband believes he has a meritorious appeal, after having given additional thought to the appeal, husband has decided he prefers bringing the matter to closure rather than pursuing an appeal, which potentially could be followed by a new trial on the value of the law firm.
Well, he contended, among other things, that the law firm was his separate property, so I assume he felt he had other things he could have argued. But,
Sure.
as a tactic, couldn't he have looked at that $460,000 judgment that he paid and say,
That's it.
That's final.
I think you're right. I think that was his theory, or at least they came up with, we have a better chance of making that argument than we would of prevailing on the sole and separate argument on appeal. And that may be correct. And frankly, the judge bought it. The second judge, Kiley, bought it. So, that's why we're here. But I think the bigger issue is what can you do about it? Because it became final.
right, but isn't it final at $460,000 for the value of the firm?
No, it didn't. And I feel like I'm beating my head here because I'm not obviously making it clear to you guys.
The wife says, I don't want any more money for the firm. My interest, what I want to get out of that lawsuit is my 25% that I own of that separate lawsuit. That's what she said. And the judge said, okay, I'll give you your $460,000 as your share of the firm, and then we'll figure out how much you own of that lawsuit later. But she didn't own anything of that lawsuit. The lawsuit belonged to the firm, which she now acknowledges, right?
This is what
You do acknowledge that she never owned.
No, and we've never taken the position. This is where I think you're wrong. And this is what her former trial counsel argued in his motion for new trial. This is the Kent Turner litigation proceeds are an additional component of the value of the law firm. Wife has no direct interest in the asset itself. Wife only has an equitable interest in the additional valuation component, which must be paid by husband. That's still our position. And that has been, as I see it, what Jeff Miller was arguing back at the time.
I'm talking about her objection, her response to husband's objection to her getting a judgment for $460,000. And so if I'm incorrect about what her response was, you know, I'm going to need to know that.
Actually,
But I
if you
think
could-
you are,
if you
but
could
Judge,
address
I don't
that.
have the response here, so it says what it says, but I think you're mistaken as to what he was arguing. Go ahead, Judge, I'm sorry.
No, I was just going to ask if you could address the precise contours of the judgment as your client framed it below. I think that might be very helpful. But if you don't have that in front of you,
The precise contours of the judgment?
well, my understanding is that husband was saying, "Wait a second, we're not done valuing this law firm," and wife was saying, "Oh yes, we are." In which case, she would have talked herself into a corner, really, because her only way to reach this asset is through a revaluation of the law firm. If I'm wrong about the arguments that were made below about that judgment, I'd really like to know. If you don't have it before you, well, we've
Yeah,
got the record.
it's his response says what it says, and I'm out of time, but if I could just say one more thing quickly here. She wasn't saying this is all I get. That was, and the
She wasn't saying this is all I get. She was saying this is all I get out of the law firm, and at that time, I think, was proceeding on a different theory that she had some right to the asset.
I disagree with you, but it says what it says.
Okay, fair enough.
Thank you, counsel. Counsel?
Good morning. May it please the court, I am Melinda Seconder, and I represent petitioner appellee Richard A. Kent. The argument on appeal appears to be that the decree was final as to the Turner litigation proceeds and how they were to be calculated, but final only as to Richard Kent. Wife filed a motion for resolution conference stating that the Turner litigation proceeds was an issue not yet decided. Well, it's either a final judgment entitled to res judicata effect, or it's not. It's not res judicata as to one party and not res judicata as to another party. Yes, when the decree was entered, there was the Section 8 that reserved jurisdiction to revalue the law firm.
I wish I didn't have to interrupt, but can you explain how that ended up in the decree? In August, it looked like Judge McVeigh resolutely refused to do that, to add it in as value to the firm, notwithstanding that everybody was talking about that. He insisted that wife was going to get 25% of the proceeds of the lawsuit, and it was not part of the value of the firm. And then somehow it ended up in paragraph 8 of the judgment.
And I don't know how that happened. I have noticed that inconsistency since
They
the
are
time.
inconsistent, are they not?
They are inconsistent, including the footnote on pages 10 to 11, which finds that the Turner litigation proceeds are an asset of the law firm,
And that she has no interest in it.
and that she has no interest in it except through reserved jurisdiction to value this asset separately, even though it's a law firm asset. I can find,
What's your position on the legality of reserved jurisdiction in this situation?
well, I don't believe it's proper to reserve jurisdiction to divide. In fact, that's one of the issues that we went through when we discussed the appeal issue. Is this even a final decree if there's a reserved jurisdiction on an issue that's not fully and finally decided? If, as she maintained in her motion to alter or amend, the value, she said she wanted the value of the law firm reduced to judgment. We said, that's not final. He reserved jurisdiction in Section 8 to revalue the law firm to include the law firm's asset of the Turner litigation proceeds.
And then she said what in response?
She said, no, that's a separate community asset, and I get 25% of it. And Judge McVeigh, in his August 29, going backwards, his August 29 order, had agreed with that position.
The part I don't get between Judge McVeigh's rulings. In August, he says the lawsuit is a community asset. Then the judgment says, no, it isn't, but we'll add some value back into the law firm. Then, when he's asked to amend it on the basis that the lawsuit is a separate asset, is a community asset, he agrees and gives her a judgment and accepts her position. I'm not sure I understand the backing and forth thing.
I'm not sure I understand the back and forth on it either. In fact, when she did the motion for resolution conference to resolve this issue, we had asked that it be remanded to Judge McVeigh so he could clear everything up, since he's the one who signed the 3 different orders. But Judge Kiley remained assigned to that issue. But the fundamental premise of their argument is that Judge Kiley couldn't do what he did because what Judge McVeigh did was final. What Judge McVeigh did could not have been final as to Turner litigation proceeds because it wasn't fully and finally decided, the issue of the Turner litigation proceeds, unless you consider them a component of the value of the law firm, which wife insisted be reduced to judgment. And then that was final. Wife didn't appeal that. This issue was dead as of 30 days after February 12th, 2010, when the amended decree was entered.
I thought that what wife was contending was final was the methodology from August 2009.
Right.
Where you would figure out what the net proceeds of the lawsuit would be, and she gets 25% of it. I thought that's what she said was final.
She says that's final, but
That's not in the decree, and it's sort of
it's not in the decree, the methodology.
affected by the decree.
Right. And that's no different than granting summary judgment on one issue but not entering 54B language in it. The judge has the power to change that judgment at any time before final judgment's entered. So there was the power of the Superior Court to reconsider the methodology as it heard more legal arguments, more evidence, because it was not an issue that was fully and finally resolved. You can't resolve half an issue and leave the remaining half, the actual calculation based upon, as the decree and the decree said, the facts and circumstances, leave that pending, but you're stuck with the methodology. Somehow that became final. I couldn't find any case that supported that, and there wasn't any in the opening brief or the reply brief. Moreover, the date evaluation was December 31st, 2007. To date, there's been no case cited that in an evaluation case, you can actually remove one asset of the law firm and separately value it at some later date.
Well, in fact, didn't Mr. Kotzen say, you can't do that? I'm going to give you the value of the firm, and then you're going to give her 25% out of the lawsuit later.
That's what he said.
And yet, wasn't his task to stand there as of December 31st, 2007 and evaluate that asset?
His task was to evaluate that asset. What he said, and it's in Trial Exhibit 48, I believe it's Exhibit 4, is that it was too speculative. There was no settlement yet.
Partly said it was too speculative, but he also said there's a formula for doing it, but I'm just not going to do it.
True. And he didn't do it. Mr. Pankow, on the other hand, husband's expert, said it has no value. So he valued it. He said it had no value. And he, in the August 27th hearing, he didn't agree that wife should get more money out of the Turner litigation proceeds.
We probably can't fault the court for not buying that argument.
Which argument?
That it had no value. Right? I mean,
but nobody offered, but wife didn't offer evidence of a value. So there's no evidence, and there's evidence of no value. Is the court supposed to speculate what value it might have as of December 31st, 2007?
Well, one option for the court, I mean, the court has testimony that it probably found rightly incredible, which is that it had no value. If it had no value, I don't suspect the firm would have been pursuing it. On the other hand, it's faced with an expert who's sort of recalcitrant and won't give it a value. In that situation, the court might naturally tend to establish a formula to determine the value when the facts become more certain, which is, I think, what it was trying to do. The problem is it did it through retained jurisdiction, which is not, as far as I can tell, legally allowed, rather than simply entering a formula and requiring the parties to live by it when the money came in. Am
If
I
the money came
misunderstanding the
in.
record? Yeah, if
She
the money came
had,
in,
I
right.
mean, Kim Kent had filed for bankruptcy. The settlement had not, as of December 31st, 2007, the settlement had not yet been reached. It wasn't reached for another 7 months, and it was still unclear whether, given her bankruptcy, whether or how much money the firm might receive.
Right, but he could have said the firm's value will increase by X percent of the value of the proceeds if and when received. And if the proceeds received are zero, then that's an easy calculation. He could have done that, and he could have ordered a staged series of payments based upon that valuation formula.
Well, if he
But
was going
he
to
didn't go that far.
He didn't go that far. He didn't do any of that. If he had, he would have also had to have accounted for all the other contingent fee cases that the firm had as of the date the petition was filed, and then if they, because none of those came to fruition, the firm lost money on every one of those, would have had to take all of those into account. And then what's the point of setting a valuation date if you're just going to keep moving the valuation date as the firm's assets change? That's sort of like, as I've said in the brief, saying that on the date of valuation of the property, stock is worth $10. If 6 months later it's worth $25, the party who wasn't awarded the stock doesn't get to benefit in that extra $15, whereas also, if it goes down to $5, the party who wasn't awarded the stock doesn't have to pay some other payment. So this is an asset, like a stock, that's valued as of a certain date.
And this is why I think 25327 contemplates that there will be some finality to these determinations,
Correct.
which is why I'm still concerned that this retained jurisdiction method exceeded the court's power under the statutes. Would you agree with that?
I agree that the court had no power to do that. Nobody challenged that on an appeal from the decree or the amended decree. And wife didn't. Wife is the one who wanted her share of the firm reduced to an actual dollar amount, even though husband was saying, but if you're going to take it into account, the Turner litigation proceeds, you have to revalue the firm.
Now, I have another question about Mr. Kotzon's testimony, because it's my understanding that in between the date of his report and the time that he testified, he added back in expenses related to the lawsuit, to the Kent litigation, whatever that's called. And his explanation was that it was a non-recurring expense, so he didn't feel that it was deductible from the value of the firm. Adding the expenses back in had the effect of raising the value of the firm and then raising wife's entitlement in the firm.
Correct.
And yet, can't that be viewed as a partial recoupment of the firm's expenses on that lawsuit? That is, ordinarily we would deduct expenses from the law firm in determining its value, because you want to know what their ongoing income is. But these were added back in as non-recurring expenses. Isn't that a way of partially recouping potential revenue from the lawsuit?
That is a way for wife to recoup
Yes.
potential revenue from the
Because on
lawsuit.
the theory that the firm at some point will not be out this money, because at some point they'll get some proceeds from this lawsuit that they're now spending money to Mariscal Weeks for, right?
Correct. That was the hope, that they would eventually get some money that they were
Is
spending.
my understanding correct that the firm spent almost $500,000 in legal fees?
That's my understanding, or more, and costs and experts.
And so how much of that had been expended as of December 31st, 2007, the valuation date? I assume that was mostly in the future, wasn't it?
Well, there were additional costs and expenses and fees because the settlement wasn't reached till 7 months after the date of valuation. Now, where Kotzen did the cutoff for expenses would have been through the general ledgers that he had received, which I believe were through the end of June 2008, a few months before the trial in this matter. And I think that the expenses at that point were 500 some thousand, and then he recaptured at the end of his calculations, I believe he recaptured just under 150,000 and increased the value of the firm by that amount of money. And so that's why when you reduce that judgment on the value of the firm to a final judgment, 460,000 is the value of the firm, now you're going to go somehow handle all of the Turner litigation proceeds and the costs related thereto, but you already have this valuation of the firm out there. You sort of have to mess with that number because you've already got almost $150,000 increased value in the firm in that number that's been reduced to a final judgment.
Well, including the expenses that he added back in that are now part of the value of the firm that now have to be taken into account in understanding the net proceeds from the lawsuit.
Correct. And
so you couldn't revalue the firm just by adding a number from the lawsuit. You'd have to go back and undo the 460.
Right. You'd have to undo the 460 and
You'd have to go back in and vacate the judgment, wouldn't you?
you would. But you're way beyond the time to do that by the time this issue comes up before Judge Kiley.
But a motion for new trial isn't the proper vehicle. It would be a motion to vacate the judgment.
Be a Rule 60C, and then it was, believe it was more than 6 months, so you could only do it for certain reasons under Rule 60C.
But it wasn't filed anyway.
But it was not filed. That motion was not
I
filed.
mean, couldn't you just net out the value of the settlement and have that net figure added to the judgment?
Net out the figure from the 460?
Let's say they receive $100 in settlement and they spent $50 getting it.
Mm-hmm.
Couldn't you just say the net value of the settlement is $50 and we'll assign the full value of that settlement to the value of the firm?
But the $50 is already added back in to the value of the firm the first time you evaluated the firm. The $50 cost you spent, Kotzen added that back in to the value of the firm. He found they were non-recurring expenses. So we added that back in. So the value of the firm went up by the cost spent trying to collect the Turner litigation proceeds. Okay. And then, so when you then try to turn the Turner litigation proceeds into an increased value of the firm, you have to take into account somehow what effect the costs of that had on the original judgment that had already been entered and satisfied.
Counsel, can you explain? You've touched on this with your discussion of the other contingent fee cases, but how was it that this lawsuit came to be separated out and sometimes discussed as a community asset, where there's other contingent fee cases that presumably have value and have expenses associated, but those apparently weren't part of this separate discussion?
Wife separated out for whatever reason she had the Turner litigation proceeds, claiming it was a separate asset of the community, separate and apart from the law firm. She did that in her pretrial.
Now, back up for a second. It's correct, is it not, that the spouse of a partner has no interest in any particular partner asset? Is that correct?
That's correct.
Does a partner have an interest in a specific partner asset as opposed to a share of a partnership as a whole?
Mr. Kent's a shareholder, and he has no interest in any particular asset of the law firm. He has no ability to do anything with it. It's a corporate asset. Corporation gets to decide what to do with it.
Managed according to the partnership agreement or the LLC or whatever it's called.
Correct. That's correct. Now, the interesting thing about Mr. Kotzen is he said that these were non-recurring expenses. They're not likely to occur again in the future, so therefore we have to add them in on the December 31st value of the firm. And yet he wants to take the almost $1.45 million as excess earnings. Well, how can that be a projection of future earnings? If the expenses were not likely to reoccur, then the gain was not likely to reoccur. So we respectfully request that you affirm Judge Kiley's order dismissing wife's claim to the Turner litigation proceeds for all of the reasons set forth in our brief. Thank you.
Thank you, counsel. We will take this matter under advisement and issue a written decision in due course. Court's in recess.
Hey, Linda, nice job.
You too. Very nice job. Challenging argument. Thank you.
I know that one. Drive carefully.
Okay, thank you.
Hi, hello.
Take your time. Switch these seats, this one's not very lucky.
Well, maybe it's due